SJC-13559, Martin L. Koussa et al. Versus Attorney General et al.
Okay, Attorney Miller.
Good morning, Your Honors, and may it please the Court. Jennifer Grace Miller here today on behalf of Mr. El Koussa and the other ballot question opponents. Your Honors, as in El Koussa 1, proponents of the 5 ballot questions before you today ask too much. They yoke together an unrelated laundry list of disparate aspects of employment law, and they redefine multiple relationships, not just the one between the network companies and their app-based drivers. This is all in violation of Article 48. I'd like to make 3 points this morning. First, I'd like to make the point that the petitions include a long list of changes to unrelated aspects of employment law, which this court has acknowledged in cases like Camargo are substantively distinct. The petitions also do more than just define the relationship between the network companies and their app-based workers. They also define the relationship between the companies, the Commonwealth, the public, and others. And finally, third today, Your Honors, I'd like to address Albano, which I believe is easily distinguished.
Do you
Start there, please, with the Albano. Yeah.
Of course, Your Honors. Albano is distinguishable for at least 2 reasons, Your Honors. First of all, it's in a unique context. Albano is in the context of marriage. Marriage is a fundamental right. It can't be different in different contexts. Employment status is different. It can be different in different contexts, as this court has already recognized. But in addition to being a unique context, I think the real difference is that Albano had a concrete purpose, a real public policy. Shall we define the marriage as between man and a woman? What it didn't have, and it left for another day, was a series of other changes to the law or a series of obvious consequences to the law that the court was going to have to deal with directly. Here, what we have is not a concrete public policy. We have an abstract public policy redefining the relationship between these 2 entities. But what we do have is a concrete list of changes to the laws that the courts and voters eventually will have to wrestle with. So we haven't left it to another day. And that's why Albano, which of course addresses the relatedness issue in only 3 paragraphs, is different. It had only a single concrete, readily understood public policy that the voters could vote yes or no on. Here we don't. We don't have a public policy, and we have a list of
Why isn't the public policy that app drivers are not the employees of the technology companies that match them up with rides?
Right, sure. Of course, that's not what proponents state the public policy is. They say it's redefining and regulating the legal relationship or the working relationship between these 2 entities. So it's not precisely that, Your Honor. But also, as this court has recognized in Camargo again, Justice Gantz was concerned about folks being, your average voter, being confused because it's difficult for a regular worker to understand what the nuances of being an employee actually are. And certainly it's difficult for them to understand what the nuances of being an employee are in separate areas of employment law, under the workers' compensation statutes, under the unemployment insurance statutes. And that, Your Honor, is why the break rooms and lunch rooms of businesses across the Commonwealth have notices in there to inform employees of what their actual rights actually are. But, Your Honor, I think
one of those notices is employment discrimination in 151B.
Right.
You don't address that, but I'm going to be asking some others. But I don't understand how this works under 151B. Are they taking themselves out of the anti-discrimination laws or not?
Right. Well, they certainly are explicitly in version B, Your Honor. Right. Version B corrects all laws and substitutes this definition in all laws in the Commonwealth. So obviously that would affect 151B as well. And of course, in the long versions, they include a mandatory contractual term that addresses or seeks to attempt to address.
So just to, because I have trouble keeping all these straight.
Sure.
So how many of these change, if, I understand there's a debate whether they are employees or whether they are independent contractors under existing law, but if they were employees, they would be entitled to all the anti-discrimination protections under Massachusetts law. How many of these 5 change that?
At least 4, Your Honor. So at least 3, Your Honor. All of the long versions would change that.
And when they have that sentence, notwithstanding any general or special law of the contrary, and any rules or regulations, and then they go on to reference 150, 151A, but not 151B, do we take that to mean that 151B is still in effect for them or not?
Well, it's an interesting question, Your Honor, because of course, 151B, under 151B, these protections are not available to independent contractors, that we know.
But we have constitutional protections against disability discrimination and other things, right? I don't know how this, I'm confused at how the discrimination laws work here.
Right, so potentially you could bring a lawsuit, Your Honor, on your own, right, as a constitutional violation. You could also bring, under the long versions, you could bring a breach of contract claim, theoretically. But what you wouldn't get is an opportunity to proceed before the MCAD. You wouldn't get an opportunity for the MCAD to actually take up your case or to resolve your case before you might go to court, Your Honor. So 151B is certainly in the mix of the kinds of laws that are at stake here. Speaking of the kinds of laws that are at stake here, the complexity of this case, I think, can be best understood by thinking about it in the reverse. So if we imagine that the Commonwealth had never put an employment law on its books, and a labor group came, organized and decided to put together a ballot question, and what they were going to do was literally draft all of the employment laws in the Commonwealth that this petition addresses. So they're going to put in protections under the wage and hour laws. They're going to do unemployment insurance. They're going to do workers' compensation. They're going to do the anti-discrimination laws. I am sure that that colleagues from industry would be here making virtually the same kinds of arguments that I am making here today, that these are unrelated, that they are too different for voters to consider as part of a single ballot. And they'd, of course, be right. And this court has also addressed when ballot question contains disparate parts, but that feel like they're interconnected, right? That's Gray. So Gray determined ultimately.
But isn't this mostly like the marijuana case?
No, I don't think so.
Creating a new industry?
No, I don't think so, Your Honor, because in the marijuana case, you had a clear public policy. Shall we legalize marijuana, right? That is something that is concrete, that's easily understood by the average voter in the voting booth. Then you had a series of implementations. But it was voters could get their arms around the public policy without necessarily understanding all of the vagaries of the tax scheme or the regulatory scheme. They could do that. That's not the question here. The question here is, shall we define the relationship between these two parties? And that simply begs the question. It begs the question, how? You can't answer, can we do that? Yes or no? You have to ask how. And when you ask how, that's when you get into all of these unrelated subjects. So it's not like Hensley, it's much more like Gray. It's much more like Gray because you have, and Anderson and Oberle's, because these ideas about work, these ideas about employment law might be interconnected. You might think of them in the domain of employment, as the court in Gray put it. But they're not similar enough for the relatedness requirement. In Gray, it was what to teach, how to test. In Anderson is what to do tax and how do you spend it. And in Oberle's, it's who do you hire and how do you afford to pay for them, right? So those ideas are all interconnected.
They're going to stand up and argue the benefit, you're creating a scheme that defines the benefits of gig workers. And that's, I worry when we start talking about discrimination, but at least I see the benefits. I understand they're different laws, but it's setting up a benefit system for these people in total. There is at least a relatedness to that, you know. An employee has the following benefits: workers' comp, unemployment insurance, and they have pregnancy rights and other things. Here, they're saying these are the benefits you get. And it seems like a voter could get their arms around at least that part of this. There are other parts of this that I don't understand. Also, there are 5 of these. I have no idea how a voter sorts through 5 of these.
You're right, Your Honor. This is the first time that that's been a possibility. But I want to quibble a little bit with uninsurance being a benefit. And I think that's a good example to show why these actually are not related. So what is unemployment insurance? Unemployment insurance is a social program run by the Commonwealth that provides benefits to workers. And it has, at least 3 underlying purposes, right? So the underlying purposes are to stabilize the economy, to provide an ability for these folks to be employed to receive benefits while they are still working. And it is, and forgive me here.
Which kind of insurance are you talking about here?
Unemployment insurance?
Right, so they don't receive unemployment insurance while they're working.
Correct.
They would receive unemployment insurance if they were terminated by their employer.
Correct.
Right? It's not just workers.
Exactly
It's
right.
employers.
Exactly right.
All right.
And so not only do these do different things, do they have different underlying purposes, but they also affect different relationships. So the primary relationship with respect to unemployment insurance, to your point, Wolhogen, is that the primary relationship is with the Commonwealth. So it's the Commonwealth that provides the benefits.
Well, but
But the employer contributes to the scheme.
But not for the benefit of their individual employees.
Is that different from workers' comp? Because workers' comp also sets up an insurance scheme that, why is that so different?
Well, it's different because it is a replacement for the tort system, right, in the workplace context. So there you have, and again, it's a different purpose, right? The idea was to relieve workers of the obligation to have to prove negligence and to give employers some sense of predictability with respect to the costs involved in any kind of work-related injury.
And so for all of these various aspects, what this petition is suggesting, and I agree with Justice Kafka that 5 in and of itself is probably confusing, but let's just assume there was 1 or 2, that what this petition's common purpose is to say, we're not going to do any of those employment laws, right? We are a different system and for which the existing employment laws do not work because of the way these individual drivers work, how they choose their hours and what they want to do. And so for that gig economy of these drivers and couriers, we're going to set up, a new chapter 159 AA. And that's what's going to govern this different kind of relationship. Why isn't that a common purpose?
Because it involves unrelated aspects of employment law, Your Honor. It's a question at too high of a generality. All of these ideas are connected only by work. Now, could the proponents have come in and potentially amended the independent contractor statute alone under Chapter 149, affecting 151? Sure, they could have done that. And that would have changed the employment relationship between these parties in the broadest way possible under Massachusetts law, but that's not what they did. They did that. They did the uninsurance laws. They did the workers' comp laws. They did the anti-discrimination laws.
What if the proposal just said, people who work in this industry for these types of companies will, for all purposes, in every context, be deemed independent contractors and not employees, period.
Right.
How is it that you could say that the components of that global proposal would not be related because it affects so many different laws?
Right. So we're back to Albano, and I would argue that in this instance, you don't have a clear statement of public policy for voters to hang on to. So the petition you just wrote, Justice Wilhojian, is not the one that was actually done. So in this particular
But I'm
instance,
trying to understand your argument that relatedness is to be determined by looking at the number of laws that it might affect, as opposed to the terms of the proposal itself.
right. So this is the terms of the proposal itself. So that's why it's different from Albano. The proponents have actually said that what we want to do is change either all the laws in the Commonwealth that touch on employment or these 4 specific areas of employment law. So we have to wrestle with what's actually in the petition. And relatedness is, the question is, are they similar enough for a voter to consider them all at once? And the answer, we believe here, is no.
I have an additional question, if I may. Do you accept the representation that only one of these proposals will be presented to the voters?
Well, that's certainly what proponents have said, Your Honor. They're not required to do that, but that is what they've said. It does make this whole.
Do you have any reason to challenge the truth of that?
No, I have no reason to challenge the truth of that.
Do they have control of that decision, though? I mean, why wouldn't, if I'm one of those people that signed one of those 9, can I keep going out and trying to keep this alive? Does the proponent control this? Or is this, the public controls it at this point, once it's out there? I don't know why they get to do this, unless the proponent has absolute control over this. I'm one of those people who signed one of those 9. God knows how they sorted through that.
Right.
Don't I have the ability to keep my proposal alive, at least if I'm one of the 5?
Right.
Whether the 5, 10 sponsors, or do the sponsors control? I just don't know the answer to that.
Yeah, the sponsors do control.
They have the
control
ability
their
to
own
turn it off?
petitions. Correct. And the secretary will ask eventually what they'd like to put on the ballot, and that's how it will be resolved.
Can you ask one other thing? The legislative history, or whatever, the constitutional history talks about this joker provision, where a joker decides to put on 5 different petitions. One involves suffrage, that we're going to have women's suffrage, we're going to have municipal women's suffrage, and we're going to have another kind of suffrage. And they're concerned that the confusion that that would induce is, you don't address that, right? I think one of the amicus does. Isn't that a problem here?
Well, I would agree that fundamentally, the framers of Article 48 were concerned about voter confusion. And that certainly goes to voter confusion and what is the single break on having multiple confusing ballot questions before the people, and that is the relatedness requirement of Article 48. So what we're concerned about is sifting through and making sure that these petitions do not contain any jokers, that they are not framed in such a way as to confuse voters, then Article 48 and the relatedness requirement should bar its publication on the ballot.
But if there are 5, I'm just trying to understand, if there are 5 different petitions out there right now, people signed
No.
different ones,
Right.
probably unable to sort through the differences, because we can't.
Not outside of a Wegmans, Your Honor. That's
So,
probably right.
but it doesn't matter?
Well, some of us can, but
Yes, Justice Wendling could sort through that, but I'm trying to, an average voter
Right.
who sees the big picture, but has a job and a family and doesn't spend hours discerning, finding differences between different initiative petitions. Those are the people we're dealing with, right? We're not dealing with, trained lawyers who have the
Correct.
time to read through all these briefs and sort this out.
Correct.
Is there a danger of real confusion here then? Again, a voter sees the big picture, but they can't discriminate at this level of detail, can they?
Right,
Maybe
no,
we can ask Attorney Hewer about that.
Go ahead.
very good, thank you, Your Honors.
Thank you. Okay, Attorney Sturman?
Good morning, and may it please the Court. Ann Sturman for the Attorney General and the Secretary of the Commonwealth. Your Honors, each of the 5 versions of the petition before you was appropriately certified by the Attorney General as meeting the related subjects requirement of Article 48. The classification-only petitions, what we've dubbed the classification-only petitions and what the opponents have dubbed the short versions, ask the voters whether to specify that app-based drivers are not employees, as that term is used in various existing statutory provisions. The classification plus benefits petitions, what the opponents call the long versions, ask voters whether to specify that app-based drivers are not employees, but should instead be entitled to a particular suite of benefits. Collectively, each petition has the effect of expanding the current binary, in which workers are either an employee or an independent contractor, to create and define, essentially, a modified independent contractor status that would apply to app-based drivers.
What is your understanding of the anti-discrimination laws? Do they still apply to these? Is buried in this some change in discrimination laws? Or, because you don't address that at all, but there are clearly, at least in 3 of these, some kind of anti-discrimination change, right, in the laws?
So I think there is, at least in one of them, a change to the anti-discrimination law.
At least in 2, right?
So-
2 of them expressly have this, we will not discriminate against drivers, and the remedy is not 151B, but the company will decide whether it discriminated, right? That's at least in 2 of them, right?
That is in 2 of the versions, yes.
And then there's a third one, notwithstanding any general laws to the contrary, and then it has a list, but it leaves out 151B. What's your understanding of, does that change? Are those people subject to the discrimination laws? Is there a change there?
So I think one distinction that's important to parse is the extent to which the anti-discrimination laws apply to employers and employees. And then there's, of course, a whole host of other contexts in which our anti-discrimination laws apply. This would affect, for purposes of employer-employee relationship, this particular employer and employee relationship, which would be defined as something
But
else.
they would not, all these people, I don't know whether they're employees or not now, but none of these people would have the MCAD process, 151B. They're all taken out of 151B?
I think under version B, that's petition 2325, that applies for the purposes of any Massachusetts general or special law, that's correct. I think it is debatable whether or not.
One of the ones still alive, I can't remember. B is still alive?
B is still alive, yes,
Okay.
Your Honor. I'll address only ones that are still alive to minimize the confusion. So
For purposes of, if I understand your answer to Justice Kafker's question, at least version B would take these companies outside of the definition of employer within Chapter 151B. But it's not clear whether any of the other 4 proposals do so?
that's right, Your Honor. So I think if I may address the other 4, they essentially fall into 2 buckets for this purpose, right? There are 2 that are classification only, but don't include 151B.
But they
Right.
begin by saying notwithstanding any general or special laws to the contrary. But then it leaves out 151B. So that means that they're covered by 151B even though they're not employees any longer?
I think it's not clear what that means.
Is that a
with respect to
problem?
151B. And I think since we don't know for certain, we don't know that it's reasonably clear that that is an implication, that that is a necessary consequence of adopting any of these petitions. I would say the same thing about the 2 long-form petitions that or the classification plus benefits petitions that do have their own anti-discrimination provision in
Right,
it,
but we
right?
generally don't have the person who's accused of discrimination decide whether they discriminated, right? That's a change in the law.
That's a change in the law that we don't know what the consequence would be, right? If an app-based driver were then to litigate whether or not their rights under Chapter 151B were entirely supplanted by this new provision in this law, I think that would be a question that would need to be resolved by a court.
Do these flaws just go to the merits for a voter versus the constitutionality?
I think they all do, right? So whether or not and how exactly these proposed laws would impact drivers under the anti-discrimination law really only matters for purposes of the Article 48 certification analysis if it renders those proposed laws unrelated. As that term is used.
I'm sorry to interrupt, but how do we figure out, since you don't know, and it's not clear from the petitions whether 151B is implicated, doesn't that go to the heart of Article 48 in preventing confusion?
Well,
Because voters won't know.
So Article 48, you are absolutely correct. The framers of Article 48 were concerned about voter confusion. But there is not in Article 48 a general provision that says the AG can refuse to certify any petition that might cause voter confusion. Instead, the framers chose to approach that voter confusion problem through specific tools, the relatedness test, right? So there may be things that one can conceive of that would cause voter confusion that were not among the things the framers conceived of and therefore not covered.
Which is why you don't address the 5 separate questions other than to say our job is yay or nay per question.
That's right, Your Honor.
It might be our job, but
I don't see anything in Article 48 as it is framed that precludes these proponents from doing what they've done. That's not the same as asking whether or not what they've done or may continue to do might result in voter confusion, right? Article 48 doesn't say the AG can't certify and the court can't bless any proposed law that may cause voter confusion.
But I understand that when I deal with UI, workers' comp, salary, but isn't discrimination a whole separate, it's different. Isn't that different from whether your benefit structure, we have a broader prohibition against discrimination than in the employment laws. Does that take this out of, I see the complexity of saying that it's unrelated, UI, workers' comp, but once you start adding in things like you're not subject to the discrimination laws, doesn't that raise a different set of issues? How's that related?
So I think it's related because it's not actually saying you're not subject to the anti-discrimination laws. It's saying you're not subject to a particular aspect of the anti-discrimination law, right, that arises from and when you have an employer-employee relationship with a particular entity. By redefining...
Can I ask another question? I just don't know the answer. When you're providing transportation to the public, I understand they don't think they're digital dispatchers or whatever, but do the anti-discrimination laws preclude, I know, for example, restaurants can't discriminate. I don't think bus companies can discriminate, right? Against the public. I just don't, how does it work when you're an independent contractor?
And I don't know the answer to that either in this context, but I think that itself is instructive, right? The answer to how this would play out in the context of this particular industry under any of these 5 proposed laws is not clear from the face of the proposed laws. And in any event, even if it were clear, that doesn't render it unrelated because it still arises from the relationship between the app-based driver and the technology company, whether that person is an employee of the company, an independent contractor, or the modified type of independent contractor that is established under these 5 proposed laws. It is still related.
Sorry, can I turn your attention to the multiplicity of the proposals?
Yes.
Do you have any reason to doubt the representation that only one of these will be presented to the voters?
I don't. The petitioners have represented that to the secretary, to this court, and to the legislature.
Is it your understanding or the Attorney General's office understanding that the petitioners have the ability to abandon 4 of the proposals at this stage of the process?
They do still at this stage of the process. So the place where we are in the process is that the second round of signature gathering is underway. That occurs between the first Wednesday in May and the first Wednesday in July. So the petitioners could, as we speak, be making decisions about which of these 5 versions they're going to collect that second set of signatures on. And even once they collect signatures, they can make a decision about which one to turn in the signatures for. Now, my understanding is that once they submit signatures for certification to the Secretary of State's office, right, then we're locked in as to what goes on the ballot.
So
But
when is
until
that date?
That would not be until the first Wednesday in July.
So if we don't issue our decision by the first Wednesday in July, we will wreak havoc. Is that right?
I mean, define wreak havoc, but probably result in these petitioners submitting all 5 to the secretary. I think that's probably the foreseeable consequence.
Okay, thank you.
Thank you.
Okay, Attorney Hewer.
Good morning, Chief Justice Budd, and may it please the court, Tad Hewer on behalf of the interveners. With me is Seth Reiner. I'd like to make 3 points. I'm not sure you'll let me get through them, but I'd like to try. The first of which is that while each of these 5 petitions has a different scope, and they do, each does establish a narrow common purpose, and the same one, and that's defining the relationship between the companies and the drivers as not employer-employee. For some purposes, it's for all the general laws. For some, it's more narrow. Second, Albano and Abdow and our other precedents are very clear. Article 48 allows a petition to amend and affect other statutes and multiple statutes, even those passed at different times for different purposes, as long as the petition's provisions, not the other laws' provisions, are related. And that's what we have here, because we have a common purpose of defining that relationship as not employer-employee. And third, each petition here took seriously and intentionally reflects this court's detailed guidance in Koussa 1 from 2 years ago as to what complies with Article 48. So on that first point, as to the narrow common purpose, the so-called Carney question from Carney, which says, what's the question that voters will be asked to answer yes or no, is coherent and simple. It is, should drivers be classified as not employees if they meet an objective 4-part test? And as to the longer version, which provides certain benefits, Clark, from just 2 years ago, was very clear, quote, initiative petitions designed to account for consequences of their primary objectives pass the relatedness test. And the benefits provisions here do exactly that.
Go ahead, sorry, go
No,
ahead.
sorry, I have, I'm sorry to take you off this topic, but your time is limited.
Of course.
I have a hypothetical for you and then a couple of questions that come from it. Well, the first is a question that's not a hypothetical. I take at face value the representation that you've made to the court that only one of these provisions will be submitted to the voters ultimately.
That's correct, Your Honor. I'm standing
And
before the
I
court. Rule 3.3 requires me to have candor to the tribunal, and I hold the Massachusetts bar card.
Okay.
That is true.
And we have ways, I think, of enforcing that if we wish. So let's assume that we accept that, and so that there is never going to be a need to go into the question of whether presenting a multiplicity of proposals to the voters in and of itself can cause some kind of Article 48 problem, whether it's confusion or creates an ambiguity as to relatedness. Let's just assume we can set that to the side. Here's my hypothetical. Assume that you only had one proposal and you had gotten it through the certification process at the Attorney General's office. And an appeal had been taken, it's pending before the court, but you've already, as a practical matter, decided that you're not going to present it to the voters. Wouldn't that question then be moot for us? And if so, why isn't, or why aren't 4/5 of this case not moot, although we haven't been told which 4/5 are? And I'll just put my cards on the table. I don't think that's a fair situation for the court to be in.
So, Your Honor, we submitted, as the petitioners, as the plaintiffs suggested, 9 petitions. Only 5 of them went to the Secretary. The Attorney General certified all 9. 5 went to the Secretary. We collected signatures on all 5 of those. There is still, as the Attorney General noted, a second signature collection phase. So even if we wished only one of these, let's say we wished it were version B, we don't get to make that choice. The voters still have to go out and we have to collect 12,000 more signatures to put that question on the ballot. It's very possible that the 5 petitions that are before the court, which we all believe meet Article 48, that voters only sign the further 12,000 signatures on 2 of them. For the court to decide that only...
Why is that our problem? Our problem is not to decide moot issues. I guess,
But it's
why is it that would you be willing to identify an order of priority?
Of course.
Which ones you would like to take to the voters or for signature?
Yes.
Because then that prevents us, that would permit us not to engage in moot questions. Do you understand what I'm saying?
Absolutely. I'm happy
Okay,
to do
so
that.
can you tell us which ones now?
Certainly.
Okay.
So there are 5 versions that are currently before the court. Those are B, F, G, H, and I.
So if we were to say that B meets the relatedness test, we need not go further.
No, so those are the 5 that are available.
He
I
hasn't
will give
given
you
the order yet.
my
Oh,
order.
I thought your order,
I'm
okay.
setting the stage for what we've got.
Okay.
In that order, we would suggest that starting with B is most appropriate because it is the broadest of them. It governs all laws, not just these 4 sections, and it has the benefits provision. If the broadest provision that deals with all the laws plus benefits is acceptable under Article 48, a fortiori, so too are the remaining 4. We would suggest then to go in decreasing order, so starting with the 3 long form, so that would be starting with B, and then G, and then H, switching to the shorter forms, F, and then I.
So
We
B,
believe that that would
G,
narrow that funnel.
B, G, H, F, I. If we decide B in affirming the AG's certification determination, we need to go no further.
I think we would technically say the court needs to go no further as to the Article 48 question because all 5 of them would be certifiable and the Attorney General appropriately certified, which is the question before the court, whether the Attorney General appropriately certified those questions. And I
But you're
think-
not saying that you wouldn't, if we were to approve B, you would terminate the process on G, H, F, and I?
We could not because we don't know if the voters will actually sign up to B, right? It's very possible the voters say, we don't like B. We're not going to give you the last 12,000 signatures. It can't go to the Secretary. It cannot appear in the ballot. That's Article 48 right there. We would need to have an option to move to the next one, even if the court and we agreed with that, to say, right, we would then move to G. And the voters say, yes, we think 12,000 are appropriate. We get 12,000 signatures on G.
So you
we would move to
want our
that.
decision on all of these, because you don't know which one's going to pass.
We don't know which one will collect the appropriate requisite number of signatures.
But
as
isn't that
required
the
by our-
case in every one of these types of cases?
I'm sorry, I'm not sure.
Every Article 48 case here.
Yeah.
The court is presumably deciding the case before anyone knows whether they're going to be the 12,000 signatures collected.
That's true. The
So
court
why
always
should
does.
that be a special consideration here?
Because the court always decides each petition individually. The plaintiffs have combined the 5 petitions into one complaint. But the question under Article 48 is, does each individual question, just as you're deciding this question separate from the one that will be argued after me and the one that you'll hear on Wednesday, you will decide each of those, not necessarily You decided this question, therefore those don't need to be reached. The
But
fact
if
that
we
there are
agree-
variations
But if we
isn't
agree
relevant.
with you, if we say that B is fine, we wouldn't have to go any further because your representation is that if B is fine, they're all fine.
That would be appropriate. If the court says B is fine and therefore we need not go further because all 5 are fine, that's appropriate. I took Justice Wilhoven's question to be, if you say B is appropriate, we need to not go further and decide on the
But
remaining
B,
4.
isn't B one of the provisions that has this special anti-discrimination process in it? B has this provision says, again, correct me if I'm wrong, because again, I have trouble keeping them straight. But I thought B says, we've added this special provision that these people cannot be discriminated against, but that doesn't mean you do it under 151B. You appeal to the company, and they decide whether they discriminated, right? That B has that provision in it?
B does, but I want to make a distinction here.
Go ahead.
There's a difference between 151B and where it falls in which statutes are affected, and the provision that you just identified, which is in the driver contract.
Can you help me understand, again, if all of these people are employees, they would all be subject to 151B and the anti-discrimination laws.
Correct.
If they're independent contractors, even the AG wasn't sure exactly whether they're subject to anti-discrimination laws. But walk me through the 5 provisions quickly, and my colleagues are going to kill me. But I just want to understand what the anti-discrimination effects of each one of these are to you.
I can do it in a more
Go ahead.
rapid manner because I think this way it's possible to do it in 2. There's version B. Version B is the long version that affects all Massachusetts statutes, right? One of the Massachusetts statutes is, of course, 151B. And this is the same as we saw in Albano. Albano says if you affect numerous different statutes passed at different times for different purposes, as long as you have a common purpose in your petition, you're related and you meet Article 48. So our position is yes, that would affect, in the situation where we have not an employer-employee relationship, a statute that says it has a relation to an employer or an employee, 151B is affected as an Albano. For the other 4, those are 149, 151, 151A, and 152.
But do
152B
GH
is not mentioned.
Do G, H, F, and I wipe out 151B protections, or do they not?
I don't believe they do, because they are not referenced. In statutory interpretation, we look at what we say, and what we say is, notwithstanding the purpose of any general or special law or rule or regulation promulgated thereunder, for the purposes of 149, 151, 151A, and 152B, there will be no employer-employee relationship. Excuse me, 152. 151B is not referenced. It's notwithstanding any other law for the purposes of those 4 statutes.
But the beginning of the statute says you're not an employee. So,
Correct.
So when I combine you're not an employee with the fact that notwithstanding, how does that work? You're not an employee, so are you outside of 151B?
You are not an employee for the purposes of 149, 151, 151A, and 152.
Okay.
You are, to the extent that it is possible to be an employee for the purposes of 151B and that matters, then yes, it would apply. I think the other thing we'd note is that in Koussa, the court instructed us, and we took very seriously, this notion of not directing the court as to what a future interpretation or outcome is. So I'm slightly hesitant to say definitively what it is or not.
You don't have to tell us.
Right.
That's something
But
for
just
here.
because of that reason.